All right, welcome everyone. Make sure I'm recording. Oh yeah, we are. All right. Sorry about that, folks. Had to make sure we were recording. This is CJ105 Criminal Law at Park University. My name is Bill Bauer. I'm the instructor for this course. This is week 2. All right, week 2, we're going to be talking about the principles of criminal law and what needs to be done, what needs to be proven in a particular criminal act according to the law. And one of the things we're going to be talking about, of course, is the elements. The elements are the things that a prosecutor must prove in court. So we're going to start out with, first I want to remind everybody that for week 2, the assignment is to do your discussion board research and responses. Okay. Remember your first response, which answers at least 2 questions in the discussion board area with good research material. Answer the questions. Go beyond the textbook. Use the information that you can find in the bibliography area of the course. Those are links that I have provided to help you begin your research. Also use the McAfee Online Library, which has lots of good criminal justice journals, periodicals, and so on that will help you answer the questions. Your first response is due before Thursday, 11:59 p.m. Central Time. You must also have at least 3 quality replies to fellow students or myself sometime during the week before Sunday night, in which you provide a good quality answer. Something beyond a compliment to a fellow student or critiquing how well another student did their research and answered the questions. Add something about the topic. Okay, so if the question or the topic that a student is talking about, or several fellow students are talking about, is voluntary acts, add something to it. Add an example. Add case studies. Add some more research material that you found that will add to what they have had to say. Add something to it. If all you say is, I agree with you 100% about what you said about voluntary acts being important, you've done nothing. All you've done is agreed with them, repeated what they said. Maybe you repeated it in your own words, but you haven't added anything. Likewise, if you give a compliment, gee, what's your research and your explanation helped me understand it so much better. It's very nice, and compliments are always welcome. However, it's not on topic. You need to have at least 3 quality replies on topic. Now you can have many more than that. That's fine. You can have, I've had students have 15, 20 different responses during a week. Some of them, most of which would be very responsive and high quality. Others, maybe just compliments, but they've got lots of them, so it doesn't make any difference. They still meet the minimum requirement to get their full points for the discussion board. Okay? So remember, your initial response, in which you answer 2 questions that have not already been answered by fellow students, is due by Thursday night. Now, once all the questions have been answered by other students, you can just pick any 2 you want. Main thing is, the first few students have to pick topics that have not been yet selected as yet by Thursday night. Okay? Also, you may want to begin starting your research for your week 3 essay. Get a head start on it. Why not? Got plenty of time this week, right? We all do. So, begin the research. Again, use the bibliography area, use the McAfee Online Library, use the legal research area. Legal research in your course area will give you instructions on how to use LexisNexis, which is a legal research tool. We lawyers, I'm a lawyer as well as being a retired police officer and a few other things. We use that to research law, to research cases. What you're looking for is to research statutes for a state. Okay, pick a state, any state, as long as it's one of the 50 in the United States. Research the statute for either parties to a crime, which in modern law are accomplices and accessories. In common law, which you'll have to research using the web. It was principles in the first degree, principles in the second degree, accessories before the fact, accessories after the fact. Okay, that's the parties to a crime. Those are the things you'll be researching. Common law, you'll have to research. You normally will have to research using Google, Bing. Look them up in the textbook. Look them up in the web using the bibliography links that I've provided for some of them. But then you need a state statute. In the case of parties to a crime, you'll probably need two. Many states have a statute that defines what a criminal accomplice is and what a criminal accessory is. They're different. If you find one but not the other, you'll only get partial credits. You want to start getting your research done now. If you decide to use inchoate crimes instead of research inchoate crimes instead of parties to a crime, inchoate crimes that we're looking for, and you only have to research one of these, will include attempt, conspiracy, or solicitation. So that's criminal attempt, criminal conspiracy, or criminal solicitation. All right? If you do an inchoate crime, please do not tie it to an underlying crime. For example, attempt can be tied to burglary, murder, robbery, rape, and so on. We're not concerned with those underlying crimes. We just want to know what would be criminal attempt. How close does the offender have to get in your state to completing the crime to meet the requirements of attempt? Okay? So begin researching those. If you have questions for the essays, the research on the essays, please be sure to contact me. You can send me an email. You can put a message in the office area of the course. I check the office pretty much every day. I check my emails almost every day. Occasionally I miss, especially if there's a football game or a basketball game I want to watch. But normally I catch it every day. Or if all else fails, call me. My cell phone number is listed in the office area as well as the syllabus, 517-290-8578. Okay, so let's begin talking about some topics so we understand what we're talking about. Okay, the textbook does a really good job of summarizing. There's outlines in week 2 tab that will also provide some outline information. There's also a written lecture in week 2. Just as there's a written lecture in week 1, there's a written lecture in week 2 that you can read. This lecture is designed to help explain a little more detail about some of these different topics. Okay, so general principles of criminal liability. General principles, in other words, the elements, the things we're going to have to prove. Okay, the prosecutor has to prove these. Remember, last week I mentioned we're not so concerned with punishment or what punishment the laws provide. Rather, we need to know what the prosecutor must do to prove their case. Okay. Constitution requires that we have a criminal act, folks. There's got to be a criminal act. We have to have criminal act to meet criminal liability. Okay? That's kind of circular. We're saying we have to have a criminal act so there's criminal liability. To have criminal liability, we have to have a criminal act. The main thing, what we're looking for is that thoughts alone are not enough. Okay? We can think about, gee, I would really like to beat the, what out of this other person. Oh, gee, I would really like to take that car for a drive. Gee, I really would like to have that jewelry. But that's not a crime. It's not a crime until there is an act. An act that can result or will probably result in a harm. A harm could be either physical or financial. So we're looking for an act. The person actually has to act upon their thoughts. Now, there's 2 types of crimes that lead to criminal liability. There's criminal conduct, and then there's criminal conduct that's causing criminal harm. Not all crimes can create harm. Okay? If we think about this, some crimes like gambling, there's no criminal harm involved. Prostitution, there's no criminal harm involved. Drug dealing, there's no criminal harm involved. Drug use, drug possession, no criminal harm involved. Possession of stolen property, no criminal harm involved. Nobody is being directly harmed by those particular acts. Okay? All right. Just want to make sure I'm still on here. So we have crimes that have no criminal harm. There's three things that we have to be able to have. Three categories of evidence that we're going to need, elements that we're going to need. One is the actus reus. Actus reus. It's a Latin term. Okay, actus reus means voluntary criminal act, a criminal act. All right. Several things that we have to understand about criminal acts. Well, we'll get to that in a moment. The next thing we have to have for criminal conduct is mens rea. Means criminal intent. Not just, gee, I think I want to do something, but really intend to do something that's criminal in nature. And then we have to have concurrence. All three of these are required categories of elements that we need for criminal conduct, to prove criminal conduct. All right? Now, if we have a crime such as robbery, rape, burglary, murder, larceny, fraud, these are causing harm. Physical harm, financial harms, these are crimes that cause harm. And we have to have two more elements, causation and resulting harm. For those of you who may decide to become a lawyer at some point, you become a paralegal, these become very important to you. You're going to need these in law school. You'll learn these in law school in much more depth than what we're getting into here. But you'll have to learn all this. Even as a law enforcement officer, as a correctional officer, like I said, paralegal, attorneys, judges, pretty much anybody in the criminal justice system has to understand that all these have to be up here. They all have to be proven. So let's start out with actus reus, the criminal act. Okay? It must be voluntary. Voluntary can be somewhat confusing for many people, especially if they start looking at crimes like voluntary manslaughter. Voluntary manslaughter and this term voluntary, separate ideas, completely different ideas. When we're talking about we have to have a voluntary act, it means we got to have an act resulting in a violation of law, right? And it has to be voluntary. In other words, the person controlled their bodily function. Like right now, I'm waving my arm back and forth, and I'm speaking to you, and I'm tapping on the ceiling and whatever. These are all voluntary, okay? Somebody takes a swing at me, and I throw my arm up to block it. That's a voluntary act. I'm conscious. I'm thinking. My brain is thinking, and it's a voluntary act. So to understand voluntary acts, the best way to do it is to understand what an involuntary act is. That way we understand what everything else has got to be voluntary. Involuntary acts are acts that may occur when the person cannot consciously control their physical being. Okay? For example, if during an epileptic seizure, a person's thrashing around, they're out of control, they have no conscious control over themselves, and as somebody's trying to help them, they reach up and they slap them. And normally that would be a criminal battery. Okay? Normally that would be battery. But for our purposes, that becomes an involuntary act because they have no conscious control over that slapping action. So epileptic seizures, diabetic seizures, any kind of seizure can eliminate the voluntary part of an act. Sleepwalking. There have been many people over the centuries who have this habit of sleepwalking. Maybe they'll become more violent as they sleepwalk. Maybe they steal while they're sleepwalking. There's all kinds of things that people will do while sleepwalking. But they're unconscious. They're not controlling anything. Their subconscious is dealing with it. So that becomes an involuntary act. Person driving down the highway has a heart attack, goes across the median, hits another car. That is an involuntary act. They cannot control their actions while having a heart attack or a stroke. Under hypnosis, you are committing involuntary acts. So now you can kind of see what involuntary means. Okay, it means that you cannot control what you're doing. All right. Now, some people look at involuntary as well as coercion, duress, those kind of things. Yet those are not necessarily involuntary because you still have a choice. You still control your arms, your legs, your body. So it's still a voluntary act. You just may not have a lot of choice involved. Involuntary manslaughter. It's only involuntary because there's no intent to kill. Where voluntary manslaughter, there is an intent to kill. Involuntary, no intent to kill, but there's other intentional acts that create the involuntary manslaughter issue. And as I said, in a couple of weeks we'll be talking more about crimes against persons. Involuntary manslaughter will be discussed in more detail then. So we have to have a voluntary act. Okay. Mens rea. Mens rea is criminal intent. All right. Criminal intent kind of falls, if you look at the model criminal code, or model penal code, it's going to define it somewhat like purpose, acting on purpose or with a conscious object of causing harm. Knowledge, acting, knowing, but without the conscious purpose or object of causing harm. Recklessness, which is acting with conscious creation of high risk of harm. Negligence, acting with an unconscious creation of a high risk of harm. You should notice carelessness is not criminal. Okay, that is not a criminal intent. It has to be reckless, negligence, or you know that what you're doing can cause great harm, or you actually mean to do it. And purposely fits most things like murder 1, murder 2, robbery, rape, larceny. Those are purposely. You are doing it on purpose with a specific intent. Okay? So mens rea is a criminal intent. Now we can have the acts that cause harm without criminal intent. All right? Let's say a hunter is hunting in the woods. He shoots at a deer. Misses the deer completely. I've known lots of hunters that can't hit the broadside of a barn, let alone a little old deer out in the woods. Bullet sails past the deer. Goes down through the trees another 200-300 yards, hits another hunter in the leg. Okay? There is no criminal intent to cause great bodily harm to that other hunter in order to shoot him or her. So without the criminal intent, there is no crime. Now, if there was an intent to wound that other hunter, maybe they're hunting in the same area and the other person's mad, well, now I've got intent, I did it, now I've got both of these are there. Okay? So, criminal intent means that you intended to commit a criminal act and you understand the ramifications, the consequences of what's happening. All right? Many times we look at defenses to certain types of crime, and we'll have defenses of age or insanity, mental deficiency. These are defenses that impact mens rea. It's impacting the mens rea because the person cannot form the criminal intent to commit the crime. And it has to be there. In fact, you have to have actus reus, mens rea must be in concurrence. In concurrence. Concurrence means that if I come up with a criminal intent, a criminal thought, then the act must be in concurrence, must occur with that intent. Okay, so for example, if I think in my mind, the guy across the street really bugs me and I'd really like to hurt him. Okay, I've got a criminal intent in my mind. That's a criminal thought. But I don't do anything. 3 weeks later, as I'm backing out of my car, I accidentally run him over as he's walking behind my car. Okay, well, if we didn't have this requirement of concurrence, one could argue that these two were met. But they didn't, because the intent and the act did not occur together in concurrence. Okay? Causation. When we move into crimes that cause harm, we have to have causation. Causation has two parts. We have the legal, also known as but for cause, and we have proximate cause. Okay? Both of these have to be in place for causation to be met. We have to be able to prove this is an element of a crime, such as robbery, larceny, rape, murder, so on. We got to show causation. We got to show that this actus reus, mens rea, acting in concurrence, caused the resulting harm. So we got to show this causation. Legal but for causation, very simple. We can look at it as but for the offender's actions, the harm would never have occurred. But for the actions of the offender, no harm would have happened. Okay? The other one is proximate. Proximate means, is it fair to hold the person responsible for the cause? Normally we look at that as foreseeability. Okay? Hang on just a second. Let me reach in here. All right. Foreseeability means, is it foreseeable that the harm could result from the actions of the offender? Is it foreseeable? A great way to look at this is an offender enters a convenience store, going to commit armed robbery, pulls out a gun, points it at the clerk, says, "Give me all your money." Standing around this offender are a group of customers. One of those customers happens to be a little old lady, and she grabs her chest, falls down to the ground, has a heart attack, and dies. Okay? But for the suspects or the offender's actions, the little old lady would not have gotten so scared to have a heart attack and die. Proximate. Is it foreseeable that entering a convenience store to commit an armed robbery, there would be a customer that may have a heart condition, maybe elderly with a heart condition? Yes, of course there is. They enter stores all the time, so it's foreseeable that they would be there. So in such a case, the legal but for is there, the proximate is there. So now this offender has met the requirement, the causation for the death of that little old lady. And when we get into property crimes, crimes against persons, we're going to talk about felony murder a little more. Essentially, felony murder means any death that occurs as a result of a commission of certain listed crimes. Robbery is one of those listed crimes. So it becomes a first-degree murder charge. Little old lady dies. We've met the legal. We've met the proximate. She dies. Offender can be charged in many states. Some states have gotten rid of this, but many states under felony murder, first-degree murder charge. Okay? So we got actus reus. We have mens reus. We got concurrence. We got causation. Resulting harm. We have to be able to prove the harm actually exists. This is normally pretty much a shoo-in. I mean, if we have a crime, we can see the harm. Money's been lost, car's been stolen, property's been damaged, person's been injured. We can see the harm. Pretty simple, showing the resulting harm. But we got to make sure that this resulting harm is related to the causation, which was caused by the concurrence of the mens rea and actus reus. Okay? So these are all elements of crimes that you have to prove. This is what we call the body of the crime. Okay? The elements, the body. Now, as you look at the statutes for each type of crime, you're going to run into different terminologies having to deal with harm, or having to deal with these. Just lost my train of thought for a second. As we look at statutes, the one thing you don't want to say is murder requires an actus reus, a mens reus, and concurrence. Well, of course it does. But what are they? Each specific crime has, remember, those specific parts that we need to talk about. So, for example, in a murder case, the actus reus is the unlawful killing of another human being. That's the actus reus. The mens rea may be with premeditation, or with criminal intent, or purposeful. Maybe if it's second-degree murder, it might be depraved heart, with a depraved heart, which has a legal definition. So we actually have to fill these in from the statutes. For example, burglary, actus rea, may be the breaking and entering or unlawful remaining in a structure for the purpose of committing another crime. The mens rea is the intent to commit another crime or theft after that break-in. So we get breaking in, or unlawful remaining under modern law. We'll talk more about these later. Mens rea is with the intent to steal. Concurrence, they happen together. Causation, legal, but for this person committing this crime, the property would never have disappeared, the house would never have been broken into. Is it fair to hold this person accountable? Is it foreseeable? Yes. Resulting harm, loss of property. All these are met. But we have to show what they are. We have to fill in these categories. We can't just say, you have to have an actus reus for murder. Well, yeah, of course you do. You have to have an actus reus for rape. Of course you do. But what is it? What is the act that we're punishing, or we're going to find the person guilty of? That is what needs to be in here. The intent needs to be in here. The concurrence needs to be here. We need to be able to show all these things. Now, sometimes you'll also see circumstances listed. That's not necessarily something that has to be proven. But for example, circumstances could be under common law burglary. It had to be in the nighttime. Okay, circumstance had to be at night. I would say that it's probably also part of the actus reus, but it's not an actual act, so we would throw it in circumstances. Okay, going back to mens rea. All serious crimes and most other crimes require proof of mens rea, criminal intent. However, we do have certain types of crimes we refer to as strict liability crimes. Strict liability crimes are crimes in which the prosecutor does not have to prove intent. Now, strict liability crimes are generally very minor in nature. And because they're so minor, the courts do a balancing act. They balance your right to have the prosecutor prove intent versus public safety issues and the penalties involved. So normally a strict liability crime, you're looking at the penalty is going to be a fine. There are a few that will have short prison terms or jail terms. But most are very minor in nature, and they're always weighed in as public safety being more important than proving the intent, such as most traffic violations are a strict liability crime. In drunk driving cases, we do not have to prove an intent to get drunk and drive. All we have to prove is that the actus reus, that it occurred. Okay? The same with speeding violations, stop sign violations, red light violations, illegal passing violations. The prosecution does not have to prove an intent to do it, only that it occurred. So this part, the mens rea and concurrence, disappears. And so we don't have to show those. And because these are not crimes that cause harm normally, these all disappear as well. So for speeding violations, red light violations, so on, we only have to prove a voluntary act. The person did it, they controlled their actions. That's all there is. Now there are some others, for example, in some states, selling or giving alcohol to minors is a strict liability offense. The prosecution doesn't have to prove intent to do it. They don't have to prove negligence or carelessness or recklessness or anything else, just that it occurred. In those cases, however, the offender still has some defense. It's not like, well, you did it, so you're automatically guilty. If they can demonstrate that it was reasonable to believe that the person receiving the alcohol was of legal age to obtain the alcohol, they may have a defense. The same would apply to selling or giving out tobacco products to somebody underage. Possession of stolen property. In many states, possession of stolen property is a strict liability offense. Only have to prove that they had the stolen property in their possession. They still have the ability to demonstrate that it was not unreasonable to believe that the property was validly sold to them or given to them, and they had no reason to believe that it was stolen. Okay, so they can still have that defense. Now, the most serious crime I can think of, besides possession of stolen property, that has this strict liability element would be statutory rape. Okay, statutory rape is an adult, normally over the age of 18, having sexual encounters or performing sexual acts with a minor who is of less than legal age of consent. Now, every state has different ages of consent. I've seen some states with 14, some with 15, some with 16, a few with 17 as the ages of consent. Usually, they will also have a separation, an age separation between the victim and the offender. So if it's illegal, let's say, to have sex with someone under the age of 16, but the person having sex, and they're having having sex with somebody that's 15, but they're 16 or they're 17 or even 18, they may not be charged because many states will use a 4-year difference. So to be charged for having sex with a 15-year-old, you'd have to be older than 19, say 19 and a half. But it's strict liability because the prosecutor does not have to prove intent to have sex with a minor. Only that there was intent to have sex, and it happened to be with a minor. So all we're really proving is the actus reus, that sex with a minor occurred. We don't have to prove the mens rea part, that there was an intent to have sex with a minor. I mean, somebody intends to have sex with a minor, they're going to lose no matter what happens. Okay? If they know the person's a minor and they intend to have sex with them anyway, mens rea would have been met. But we don't have to prove it in court. And the reason the courts allow this particular case is because as a society, we hold juveniles very dear. We want to protect them. And we want to protect them from adults that can take advantage of them in sexual ways. So it's a strict liability crime. Now, virtually every other crime, all other serious crimes, you're going to have a mens rea requirement met in order to get a conviction. One thing I didn't mention as an act is possession charges. Okay? Possession of, let's say, illegal firearms, let's say drugs, alcohol, whatever. Illegal possession of some item. The actus reus is a little difficult to do because there's no real action involved. I mean, if I got, say, a baggie of marijuana in my pocket, I'm not doing anything. I'm not acting. My body's not doing anything. So it becomes more of a passive action. Okay? It's more of a passive act. There's still got to be intent. You got to know what you've got. In fact, most states will have different types of possession charges. Possession of cocaine, possession of methamphetamines, possession of marijuana, possession. You got to know what you have to meet the mens rea, okay, under those statutes. Very specific intent there. Possession, we have two different types. We have actual. I'm not going to clear all this out, but we have actual possession, which means it's on you. It's in my pocket. It's sitting next to me in my car. I'm touching it. It's in my hand. Actual possession. Constructive possession is another passive actus rea, but it means that I have control of it, but it's not on me. Maybe it's in the back seat. Maybe it's in the seat next to me in the car. Maybe it's in my trunk. Maybe it's in my apartment or my home. Maybe it's 4 or 5 feet away from me where I can control it. It means I can reach out, touch it, and do something with it. Okay? That's constructive possession. This is where many teenagers, in fact, and maybe some of you hopefully have not run into this, but as a law enforcement officer, I've had opportunities in the past where I've pulled over a car, got a group of teenagers in the car, 1 or 2 of them are drinking alcohol, the rest of them are not drinking alcohol, but the alcohol's in the car, and they know it's in the car. They can see it. They can touch it if they want to. They are in constructive possession of alcohol. Even if they're not drinking it, you're still in possession of it. And that gets some people into trouble. There's 2 other types of possession that go with active and constructive. One is knowing possession. In all but 2 states, knowing possession is a requirement. Okay? Person has to know what they're in possession of. Hang on a second. I want to make sure that I have not lost my camera. All right. They have to know what they're in possession of. I defended a young lady a number of years ago. Fortunately, we didn't have to go into court. We came up with a plea bargain. But she was riding along with this male. The male had some crack cocaine with him. Police went to pull him over for some traffic violation. He reaches down into the door panel next to him. Of course, at this point, she doesn't know he's got crack cocaine in the pickup truck. Pulls it out of the panel, throws it across the seat to her, and tells her to stick it in her pants. She sticks it in her pants. As soon as the police get him pulled over, they get her out of the car, and the officer says, "What's going on?" She reaches in, pulls out the baggie, and hands it to the officer. Says, "He gave me these to hide." All right? She's in actual possession of crack cocaine. But she's not in knowing possession of crack cocaine because she has no idea what's in this baggie. It could have been ice. It could have been any other kind of drug in the world or some other illegal substance. But she didn't know it was crack cocaine. So under the statute, she cannot really be found guilty of possession of crack cocaine because she doesn't know what it is. She didn't have the opportunity to ask. So the law is very specific. So the last type of possession is called mere possession. That's the case, example I just gave you, case study. She was in mere possession. She has no idea what it is. Mere possession means you possess something, but you don't know what it is. Maybe your friends loaned you a car. You need to borrow a car to run down to the store. You get in the car, you drive down to the store. Halfway to the store, you get pulled over by police. They ask you for consent to search the car, and you say, yeah, sure, why not? Because you don't know there's anything in it. They get in the truck and find a pound of cocaine. You are in mere possession of cocaine. And as long as your attorney, your defense attorney, can demonstrate mere possession, in 48 of the 58 states you'll be found innocent because you didn't know it was there. I mean, how fair would that be to find somebody guilty of possession of something when there's no way they could have known what they had? Or let's say you're walking through school, through a campus, high school, whatever, and one of your friends says, here, would you carry my pack for me for a few minutes? And as you're carrying the pack, an officer stops you, they check it, there's drugs in it. You don't know there's drugs in that pack. It's mere possession. Now you can have mere actual possession, you can have mere constructive possession. In any case, as long as it can be demonstrated you had no idea that the illegal objects, burglary tools, weapons, whatever, were there, you will normally be found innocent of that crime. If you know what you've got, you're pretty much done. Okay? They're going to find you guilty. You've met the requirement. So possession is another form of actus reus, but it's a passive form because you're not actively doing something. If I stick something in my pocket, once I get it in my pocket, I'm not actively doing anything. So it still fits actus reus. It's just a passive possession. Okay? We've talked about some of these elements. Hopefully you've understood what we're looking for. And as you do your assignment next week, week 3, you'll understand that as you begin discussing the elements of a crime, let's say you decide to research criminal conspiracy, you're going to be looking for the elements under common law, English common law, to prove conspiracy, which frankly is very easy. The agreement between 2 or more people to commit a crime. Whoo, that's it. Pretty much simple. But now you've got to explain what an agreement would be under common law. Okay, so in the law, once we've defined something like common law criminal conspiracy is agreeing to commit a crime, 2 or more people agreeing to commit a crime, now we have to make sure that we define what the agreement is. For example, if an undercover police officer in the common law were to reach an agreement with the criminal to commit a crime, there's no conspiracy because the officer doesn't really mean to do it. There's no intent. Okay, they're not really going to commit a crime. They're not really agreeing to anything. The agreement is 2 criminal intent minds meeting and joining, or 2 or more meeting criminal minds. Law enforcement officer is not a criminal mind, so it misses. There's no conspiracy. Okay? So you got to make sure you define these things. Just like common law burglary talks about only occurs in nighttime. What is nighttime? What is breaking and entering? What is unlawful remaining under modern law? Be sure to define these different terms. Okay? So we've reached the end of this particular lecture. I hope it's been informative. Be sure to look at the outlines in this week's tab. Look at the written lecture in this week's tab. Read your text book. The 2 chapters involved, I believe, are 3 and 4. Do a little bit of research using the bibliography area of the course and the McAfee Online Library. Have a great week. I hope you all enjoy this particular week of topics, and we'll get together again next week.